Biden and the Democrats are outraged. The Supreme Court put the brakes on their Green New Deal. In a 9-0 ruling, the court held the EPA will not have total authority to control America's water and our wetlands in what is a major victory against the administrative state. We are going to review this ruling. You see, it's quite long. It's 82 pages. Now, there was something interesting that happened here. The ruling was 9-0, meaning the court agreed on the outcome, but the reasoning, the basis for the decision was different. It was 5-4, meaning the liberal judges and the conservative judges disagreed about why the EPA doesn't have this power, but they still said the EPA doesn't have the power, and that ruling came out 9-0. And so we're going to take a look at the opinion. In particular, want to focus on Judge Gorsuch, who's been writing some burner opinions. But first, just to show you how upset they are about this, let us take a look at some reaction. President Biden, very upset, said the Supreme Court's disappointing decision in Sackett versus EPA will take our country backwards, placing our nation's wetlands and the rivers, lakes, and ponds connected to them at risk of pollution and destruction unless the government can't take over. And water is extremely important. It's something I've been paying attention to my whole life here in Arizona, wondering how Arizona gets its water. We've had many different discussions here about how the waterways are governed by the Supreme Court, and it's as though there are little treaties that exist between the states, and they divvy the Colorado River up by gallons, and it is a complicated process. And if you lose water, you lose the ability to survive. And going back to Arizona history, we have the Hohokam and other Native American tribes who built and created great canals that we put our canals on top of. And so these are critical issues, not only for the longevity of particular regions, but also for our food and how we get our crops grown and our animals fed and food on our tables. So they're very upset about this. They want the government to regulate more of all of that. He says, my team will work with the Department of Justice and relevant agencies to review this decision and use every legal authority we have to protect our nation's waters for the people and communities that depend on them. So he's going to bring in the DOJ? If the EPA couldn't do it, he's going to bring in the Department of Justice. And who are their law enforcement officers? The FBI. And so U.S. attorneys are now going to be weaponized to go after not just the J6ers and the extremists that they allege exist, but also farmers and people who are trying to protect their water on their land. He says, our fight for clean water for all must go on, and it will. But as we know, the government is pretty terrible at managing most things, including water. Chuck Schumer was very upset about this as well. He said, the MAGA Supreme Court, see how this is going, doesn't like the ruling, even though it was 9-0, liar, is continuing to erode our country's environmental laws. Says, make no mistake, this ruling will mean more polluted water and more destruction of wetlands. We'll keep fighting to protect our waters. Now, this was an interesting double community notes on Twitter. Doesn't happen often, but we see this. The Washington Post published a story. They said the Supreme Court on Thursday cut back the power of the EPA to regulate the nation's wetlands, another setback for the agency's authority to combat pollution. And the community notes, which is a correction to the fake news Washington Post, correcting them with the New York Times, which is also fake news, but a correction nonetheless, says readers added context. All 9 judges agreed that the EPA overstepped its authority and that plaintiffs' property should not be subject to the regulation. However, 4 judges disagreed with respect to the authority with respect to wetlands. But when Chuck Schumer retweeted that and said the MAGA Supreme Court is eroding our country's environmental laws, he also got a context added to his. Same thing. All 9 judges agreeing the EPA overstepped its authority on the plaintiff's property. So they are screaming about this because they want the EPA to have unlimited power, nonstop control. And this is a pattern that we've seen historically in the United States. They will take one power and just cram an entire army of bureaucrats through a little sliver if you give them the inch. And they will do it for years. And we've seen this with the Commerce Clause, how the Supreme Court has given Congress the ability to regulate virtually everything if it engages in commerce. And the same administrative state tries to control as much as they can. They are outraged that they're being stopped in this count. And now we hear from Karine. She came out, read a statement about how upset she is with this ruling.
The court's decision today aims to take our country backwards. It will jeopardize the sources of clean drinking water for farmers, businesses, and millions of Americans. Look, the Clean Water Act is the reason why America's lakes today are swimmable,
That's
why
the
we
reason?
can fish in our streams and rivers, and why safe drinking water
that's
comes
the
out
reason.
of our taps. So
Because the
it was
government.
passed, as we all know, by a bipartisan majority in Congress back in 1972, and has since been used by Republican and Democratic administrations alike to protect our nation's land and water. So our legal team, as you can imagine, as you all know, is carefully reviewing the decision, and we'll have more to say on this soon. But know this, that President Biden will use every legal authority available to him to ensure Americans in every state have clean water, and so clean water, and it not just clean, but also certainly safe to drink. The court's decision today
So
aims.
they're going to launch the DOJ now to go and investigate Americans who they say are out of compliance. There's more reaction. Rand Paul says, congratulations to the Sackett family for getting control of their property back. I first wrote about the federal abuse in my book some time ago, a decade ago, and says that Schumer is very, very upset about it. Chuck Grassley, also from Iowa, says all 9 justices agree EPA's massive outreach with waters exceeds its authority. After all these years, it's a huge victory for farmers, builders, and common sense. The farmers of Iowa can be thankful for the Supreme Court making sure normal farming operations aren't regulated by the EPA. So, major ruling. Obviously, the Democrats are upset about it. Here's what it looks like. Out of the Supreme Court of the United States, cases Sackett versus the EPA. We've got petitioners. The people who brought this claim are the Sacketts, named Michael and Chantel Sackett. They purchased property in Idaho and began backfilling the lot with dirt to begin building a home. Their property, they want to build a house on it. The EPA informed the Sacketts that their property contained wetlands and that their backfilling violated the Clean Water Act. Says you can't discharge pollutants into the waters of the U.S. So the EPA ordered the Sacketts, who already started work on their property, to restore the site, threatening penalties over $40,000 per day. How dare you use your property the way you want to? The EPA classified the wetlands on the Sackett's lot as waters of the United States because they were near a ditch that fed into a creek, which fed into Priest Lake, which is a navigable intrastate lake. A ditch fed into a creek, which fed into a lake, which was an interstate lake. Therefore, it's intrastate within the state. The Sacketts sued. They said, what are you talking about? It's intrastate. It's not waters of the United States. You don't get to come in here and control this because it goes into a ditch that goes into a creek. Psychos. The district court entered summary judgment for the EPA. So the lower level court said, well, sorry, they're the government. They can do whatever they want. Ninth Circuit affirmed it, saying the Clean Waters Act covers wetlands with an ecologically significant nexus to traditional navigable waterways, and the wetlands satisfies that standard. So very low standard. If you have anything that basically touches any water in the United States, EPA has now control over it, and they can tell you what you can do with your property, whether you like it or not. Huge range and scope, if that is to be affirmed. Let's see what the court said. Held, the ruling from the Supremes, says the Clean Water Act's use of waters as defined by the law refers only to the geographical features that are described in ordinary parlance as streams, oceans, rivers, and lakes, and to adjacent wetlands that are indistinguishable from those bodies of water due to continuous surface connections. So that's the definition this court says we're going to be following now. To assert jurisdiction over an adjacent wetland, a party must establish the following. First, the adjacent body of water constitutes waters that are traditionally connected. The uncertain meaning of this phrase, the waters of the United States, has been a persistent problem, sparking decades of agency actions and litigation. And so we need to determine this phrase. They give us a lot of history and backdrop and procedural background, and we're fast forwarding through most of it. The court says, in summary, summarizing all of that, the Clean Water Act extends only to wetlands that are, quote, as a practical matter indistinguishable from waters of the United States. This requires the party asserting jurisdiction to establish that the adjacent body of water is the United States, and this is where water ends and the wetland begins. They say after all of this analysis, the EPA's arguments cannot be reconciled against the law. And because it falls short, it is reversed and remanded. Very technical opinion there, which is the summary of the entirety of the court. But as we can see, there were differences of opinion in other details. So this was an opinion delivered by Justice Alito, and Gorsuch joined that opinion. Judge Thomas also filed a concurring opinion, and Gorsuch joined that opinion. Kagan filed an opinion. Sotomayor and Jackson joined that one. Kavanaugh filed his concurring opinion, and Sotomayor, Kagan, and Jackson joined. So it's a very interesting mixture of people joining. Kavanaugh is joined by Sotomayor, Kagan, and Jackson. Sotomayor, Jackson, and Kagan all join. Gorsuch joins with Thomas. Let's see what some of these say. This one came from Justice Alito. He says, this case concerns a nagging question about the outer reaches of the Clean Waters Act. By all accounts, it's been a pretty good success, but there is an unfortunate footnote. What does it mean to be waters of the United States? How do you distinguish between swimming pools and puddles and wet meadows and playa lakes and prairie potholes? How about ditches and swimming pools and puddles? Many agencies have wrestled with these interpretations for quite a long time. I think somebody's here again. He's on this side now. Yeah, it's leaf blower guy. For most of this nation's history, the regulation of water pollution was left almost entirely to the states. Congress's early efforts at directly regulating water pollution were tepid, so they created a bunch of new rules. They replaced the scheme with Clean Waters Act. EPA is tasked with enforcing it. Michael and Chantel Sackett have spent well over a decade navigating this problem. 2004, they purchased a small lot near Priest Lake in Idaho. They began backfilling their property with dirt and rocks. EPA sent them a letter. You're in violation. You have to restore this site because there are wetlands on your property. They filed a lawsuit under the EPA. We granted cert in order to hear it. He says, with the benefit of half century of practice under the Clean Waters Act, we should take a look at where things stand. The agencies now maintain that if there is a significant nexus between the property and other waters, that's enough. But what are landowners to do if they want to build on their property? They say, well, you should ask us first for permission. But what if they don't get permission? They can't build lest they be in violation of the law. So he goes through, he gives us an analysis. He says, let's start with the text. And they're spending a lot of time literally defining this. What does the water of the United States refer to? Traditional navigable waters is where they're backing this up to. Can you navigate it? And they're just trying to define this stuff. You can see it gets very technical. And we're going through dictionary definitions, Oxford American Dictionary, Webster's. What does adjacent even mean? It says it would be odd if Congress tucked an important expansion into this because we say that Congress is not supposed to hide elephants in mouse holes. They're not supposed to be sneaky here, and the EPA is trying to say they're being sneaky. So in sum, Alito holds with the court that the Clean Water Act extends only to those wetlands that are, as a practical matter, indistinguishable from waters of the United States. This requires the party asserting jurisdictions, like in this case the EPA, to establish that the adjacent body of water constitutes waters connected to traditional interstate navigable waters, and second, that the wetland has a continuous surface connection with the water, making it difficult to determine where the water ends and the wetland begins. So that's very different, right? We've got actual surface connection. It's basically indistinguishable from one another. Much, much, much higher standard. One standard, if you have like a leaky hose that runs into a ditch, that runs into a creek, that runs into a lake, maybe that's enough for the EPA to have jurisdiction. In this case, Supreme Court said, nope, much, much higher standard. It has to be so connected, not a creek into a stream into a lake, that you can't even tell the difference, basically. So if you have a property that has wetlands that look like they run into a lake or a river or a stream or something, you can't distinguish between the two, then you're probably going to have to do some investigation on what you can do with that parcel in your property without running afoul of the EPA. But if not, if you have a creek, if you have something that is much more distinguishable, the EPA does not have jurisdiction over it, according to this court. And so major win for property owners, for farmers, for people who want to have control of their property. The EPA wants to gobble up more bureaucratic administrative state power, The Supreme Court did something good, denied them that ability.